Hello everyone, welcome back to MAYANK LAWHOLIC. In this video, we will be pursuing the MCQs of jurisprudence, and this is the 6th video in the series. If you want to watch other videos also, please find the link in the description section, and also please subscribe to us. So now let's get started from question number 126. Question number 126, assertion: Savigny was Darwinian before Darwin. Reason: Savigny applied the theory of evolution to law before the enunciation of the doctrine of evolution by Darwin. Quotes: both A and R are true, and R is the correct explanation of A. B, both A and R are true, but R is not a correct explanation of A. Option C, A is true, but R is false. And option D, A is false, but R is true. Here, correct answer in question number 126 is option A, that is both A and R are true, and R is the correct explanation of A. Question number 127. The purity of Kelsen's pure theory of law rests on the facts that Kelsen, option A, defined law in accordance with morality and purity. Option B, discussed jurisprudence in all its purity. Option C, separated law from history, religion, ethics and politics. And option D, discussed law purely in terms of justice. Here in question number 127, correct answer is the option C. The purity of Kelsen's pure theory of law rests on the facts that Kelsen separated law from history, religion, ethics and politics. Question number 128. The main difference between historical and sociological school of jurisprudence is that the former gives importance to state and later to society. Option B regards custom as a source of law and the latter does not. Option C gives permanent role to judges in shaping the law while the latter does not. And option D concentrates on the past practices in shaping the law while the latter does not. Here in question number 128, correct answer is option D. The main difference between the historical and sociological school of jurisprudence is that the historical school concentrates on the past practices in shaping the law, while the sociological jurisprudence does not focus on that. So option D here is the right answer. Question number 129. Who among the following propounded the theory of 𝐭𝐥𝐡? Option A, Henry Mayen. Option B, Montesquieu. Option C, Roscoe Pond. And option D, Savigny. Here correct answer is option D, that is Savigny. Savigny propounded the theory of 𝐭𝐥𝐡. Question number 130. Consider the following statements. Pure theory of law propounds that option A, state and law are inseparable. Option B, there is no difference between public and private law. Option C, law is a primary norm which stipulates sanction. And option 4, legal duties are the essence of law. Which statement above are correct? Here in question number 130, correct answer is option A, that is 1, 2 and 3. Statement 1, 2 and 3 are correct, and at the last statement, legal duties are the essence of law, is not correct. Related to pure theory of law, state and law are inseparable. There is no difference between public law and private law. Law is primary norm which stipulates sanction. Question number 131. Which one out of the following statement is not correct with reference to Savigny's pure theory of 𝐭𝐥𝐡? Option A, law cannot be universal or general in character. And option B, law is found and not made. Option C, law grows with the growth and strengthens with the strength of the people. And option D, law is an instrument of social change and social reform. Here in this question, it has been asked which of the following statement is not correct with reference to the Savigny's theory of 𝐭𝐥𝐡, and the correct answer here is option D, that is law is an instrument of social change and social reform. This is not correct, whereas the other statements A, B and C are correct related to the theory of 𝐭𝐥𝐡 in Savigny's theory of 𝐭𝐥𝐡. Now let us proceed to question number 132. Balancing of social interest and the doctrines of social engineering is the greatest contribution to sociological school. This is attributed to whom? Option A, Duguid. Option B, Roscoe Pond. Option C, Savigny. And option D, Eyring. Here in question number 132, correct answer is option B, that is Roscoe Pond. Question number 133. According to John Austin, positive law is called positive because it is option A, made by a person in authority. Option B, made as a result of collective will of the people. Option C, made as a result of divine providence. Option D, followed by everybody. Here in question number 133, correct answer is option A, that is made by a person in authority. Question number 134. The concept of living law was expounded by which jurist? Option A, Austin. Option B, Ehrlich. Option C, Pond. And option D, Holland. Here in question number 134, correct answer is option B, that is Ehrlich. Ehrlich propounded or expounded the concept of living law. Question number 135. The concept of rule of law in India and England and due process in USA are essentially based on which one of the following? Option A, positive law philosophy, option B, realist approach, option C, natural law philosophy, and option D, social solidarity. Here correct answer is option C, that is natural law philosophy. The concept of rule of law in India and England and due process in USA are essentially based on the principle of natural law philosophy. This is one of the important question which you must know. Question number 136. Analytical positivism does not mean that option A, laws are in the nature of commands, option B, law as it is and is it ought to be have to be separated, option C, certain inherent and moral quality is an essential feature of law, and option D, analysis of legal concepts is distinct from critical evaluation. Here in question number 136, correct answer is option C, that is certain inherent moral quality is an essential feature of law. Question number 137. Kelsen's theory of law is called pure theory because Kelsen, option A, purely discussed jurisprudence only, option B, defined law in accordance with morality and purity, and option C, separated law from religion, ethics, sociology and history, and option D, discussed law pure in terms of justice. In question number 137, correct answer is option C. This we have already discussed. Kelsen's theory of law is called pure theory because Kelsen separated law from religion, ethics, sociology and history. Now let us proceed to question number 138. Out of the following jurists, whose theory of law has earned the name of natural law with variable content? Option A, St. Thomas Aquinas, option B, John Locke, option C, 𝑅𝐶, and option D, J. Rawls. Here in question number 138, correct answer is option C, that is 𝑅𝐶. Question number 139. Who among the following is not the follower of natural law theories? Option A, Cicero, option B, Hart, option C, Hooker, and option D, Aristotle. Here in question number 139, correct answer is option C, that is Hooker. Question number 140. Which one of the following jurist was hostile to natural law school? Option A, Immanuel Kant, option B, Jeremy Bentham, option C, Stamler, and option D, John Rawls. Here in question number 140, correct answer is option B, that is Jeremy Bentham was hostile to natural law school, whereas Immanuel Kant, Stamler, and John Rawls were associated to natural law school. Question number 141. Now, natural law is not considered as absolute but as relative. It is natural law with variable contents. This observation specifically relates to Stamler, Delvicco, Finis, Deben. Here in question number 141, correct answer is option A, that is Stamler. Question number 142. That a legal system arises from the combination of primary and secondary rules was initiated by option A, Austin, option B, Hart, option C, Bentham, and option D, Kelsen. Here correct answer is option B, that is Hart. Question number 143. Consider the following 4 types of legal doctrines. Option A, Fox-Chest, option B, imperative theory of law, option C, social engineering, and option D, social solidarity. Identify the correct order in terms of time in which they appeared. Here in question number 143, correct answer is option B, that is 2143. That means that imperative theory law appeared in first and Fox-Chest appeared in after the imperative theory of law, and then appeared the theory of social solidarity, and at last the theory of social engineering appeared. Now, by going through these chronological order, correct option will be option B. Now let us proceed to question number 144. The balance of interest theory was propounded by option A, Rudolf Ahering, option B, Roscoe Pond, option C, Rudolf Stamler, and option D, Oliver Wendell Holmes. Here in question number 144, correct answer is option A, that is Rudolf Ahering. Rudolf Ahering was known to be the propounder of theory of balance of interest. Question number 145. According to Dugett, the division of labor is most important fact of social cohesion. He named it as a theory of social solidarity, Fox-Chest, social engineering, and social contract. Question number 145, correct answer is option A, that is social solidarity. Who amongst the following propounded the theory of social solidarity? Option A, Ahering, option B, Pond, option C, Dugett, and option D, Hart. Here correct answer is option C, that is Dugett. Dugett is known to be the propounder of theory of social solidarity. Question number 147. Which of the following jurists has termed the sociological school as meta-juristic? Option A, Dworkin, option C, Lloyd, option C, Hoffield, option D, Kelsen. Here in question number 147, correct answer is option D, that is Kelsen. Kelsen is a jurist who has termed the sociological school as meta-juristic. Question number 148. Theory of Savigny was based on option A, Greek law, option B, common law, option C, Spanish law, and option D, Roman law. Here correct answer is option D, that is Roman law. Question number 149. Historical school of jurisprudence emerged as a reaction of fact against function, realism, fancy, positivism. Correct answer here is option D, that is positivism. Question number 150. Roscoe Pond propounded the theory of social engineering, which means greatest happiness to greatest number of people, balancing of competing interests in society, changes in the concepts and functions of the state, or an option D, that law has its source in the general consciousness. Here in question number 150, correct answer is option B, that is balancing of competing interests in the society. So now we will end this video over here, and if you want to watch further videos or further MCQs of jurisprudence, please keep an eye on the another video of this series. Thank you so much. Thank you for watching. Please like, share and subscribe.